The NCAA and Power 5 Conference's $2.8 billion antitrust settlement is now facing 7 appeals, following a July 7 deadline for filings with the 9th U.S. Circuit Court of Appeals. While the settlement, finalized by U.S. District Judge Claudia Wilken on June 6, allows schools to begin paying athletes directly for their name, image, and likeness starting July 1, the ongoing legal challenges threaten to delay actual payments. No motions have been filed to pause the settlement's implementation, meaning schools may proceed with NIL payments and operate under new roster-based limits rather than traditional sport-by-sport scholarship caps. Exceptions to these roster rules apply to returning athletes and incoming recruits with guaranteed spots for the upcoming academic year. Out of nearly 390,000 eligible athletes, 73 submitted valid objections. Among those now involved in appeals are Florida State quarterback Thomas Castellanos, former lacrosse star Charlotte North, Olympic wrestling medalist Sebastian Rivera, and attorney and former basketball player Braden Anderson. Their objections reflect concerns about fairness and representation within the settlement structure. The appeals raise several key issues. One major concern is whether the allocation of damages, which heavily favors football and men's basketball, violates Title IX by creating gender disparities. Another issue questions whether the settlement's per-school cap on direct NIL payments is itself an illegal restriction on athlete compensation. Additionally, appellants argue that walk-ons and athletes from non-revenue sports received unfair treatment, and that the legal process lacked proper representation and communication for all affected athletes. Patrick Bradford, representing Castellanos and Anderson, said the settlement undercompensates athletes and suggested a Supreme Court challenge may be pursued. Meanwhile, lead plaintiff's attorney Steve Berman expressed confidence in the ruling, stating most athletes did not appeal and that the objectors risk delaying payments to thousands of eligible recipients. Under Judge Wilken's terms, settlement funds will be held in escrow during the appeal process. The Ninth Circuit has issued initial scheduling for 5 appeals, with written arguments expected in September and responses due in October. Plaintiffs intend to request that the court consolidate the appeals into a single schedule. Even under an expedited timeline, the case likely won't be resolved before early 2026, given that the appeals court typically takes several months post-submission to issue decisions. Until then, athletes and attorneys alike will have to wait as the landmark settlement faces further legal scrutiny.